Good afternoon, guys. My name is Alina Sholtsova. I'm an immigration attorney from New York. In today's live presentation, we're going to discuss with you the most recent immigration news. We're going to talk about just today's court decision from Ohio regarding enforcement priorities or removal practices that this current administration is using. I'm going to give you some updates with regard to the work permits, and I'm going to talk to you about TPS. So thank you very much for joining me. Please let me know where you're watching from, save your questions so that in the end of the presentation, I'll be able to answer them. And let's start. Well, just today, March 22nd, 2022, a district court, federal court in Ohio, issued a decision that is very concerning. It stopped the policy that Biden administration enforced or started in September of 2021 with regard to the removal priorities. It's extremely, extremely important. Removal priorities were reconsidered by the Biden administration and were changed from deporting everyone, that's what was happening under Trump, to concentrate on people who present concern for the public safety and national security. It's extremely important. So we have not seen many deportations recently because the government, DHS, was focusing on people who present threat to the national security and public safety. And this was done because of the memo that about enforcement priorities that came into effect. Hey, David, that came into effect last September. However, not everyone was happy about that, and certain states sued the Biden administration. They sued the Biden administration saying that they overstepped their authority, and Congress meant to have this otherwise. And for that reason, federal court sided with plaintiffs, and today the enforcement priorities that would concentrate only on those who have heavy criminal convictions and in addition to that present threat to the public safety and national security, that enforcement priority was overruled and stopped. If nothing changes, meaning that there is no appeal of that decision, and decision is not stayed by itself, it means that DHS will have no choice but start deporting people physically. First of all, those who already have outstanding orders of removal and deportations. They will also change their policies as to custody decisions and release from custody. Extremely important. Custody decisions for those who are in pending removal proceedings and those who are being determined if they will be released from custody. It may be relevant in the light of the surge of refugees and people seeking asylum at the southern border. This may be very relevant because, as you recall, we used to have a policy during Trump administration that people who are stopped at the border will be in detention unless they pass credible fear interview and then placed in regular removal proceedings. Current DHS practice with regard to people at the border is very different. Right now, they're being processed and released and later being summoned to court and placed in regular removal proceedings. And this is all done because of the different removal priorities. So it may change. Just letting you know. What can you do? Well, first of all, if you are subject to a final order of removal, you should consult with an attorney as to whether or not you can and you should file for administrative stay of removal. Perhaps you can file a motion to reopen depending on your situation, but it's something definitely that you need to take into consideration, this decision, and prepare. Also, for those of you who are awaiting custody decisions, perhaps you do not have access to this particular stream, but your family members may. You may also want to probably consult with lawyers and see if, it usually takes government some time to change the policies. So if you have an opportunity to advocate and ask for that humanitarian parole, this is something that should be done as soon as possible. Humanitarian parole, I'm referring to 212D, 212D5A parole that DHS may authorize at the border when a person does not have any documents to come to the United States, right? And this is the usual solution along with the conditional parole that DHS officers are using for those who are trying to come to the United States and asking for asylum at the border. This is the authorities that's being used currently by the government to release people rather than keep them in detention. So a very important trend. You need to be aware of that. You need to be prepared. Now I wanted to speak to you about expedition of the work permits. So USCIS just yesterday published new guidelines saying that those of you who are working in the childcare industry may ask for their work permits to be expedited as well. Well, those are nannies, right? If you work at private households or business or childcare institutions, schools, and your work permit is expiring, you may request for USCIS to expedite your work permit or to issue to you a new work permit. Extremely, extremely important. For that, you will have to call USCIS customer service and you have to be ready to present proof that you in fact have employment in that area. Similar thing was issued for healthcare workers about a month ago or so. If you don't work in the healthcare industry or in childcare sector, it does not mean that you cannot ask for your work permit to be expedited. What it means is that you will be subject to different standards. That's all. You still should, if you can demonstrate extreme hardship to you or your employer, if you can demonstrate, for example, that United States government interests are at stake or non-for-profit organizations' interests are at stake, you can still ask for your work permit to be expedited, even if you don't work in healthcare industry or childcare industry, just so you know. And finally, a couple words about TPS, temporary protected status. Afghanistan and Ukraine were designated for TPS recently. You cannot submit applications yet for TPS. When you will be submitting applications, I anticipate is going to be about May. Why? Because the government has to publish a notice first in Federal Registry. That has not happened yet. TPS is absolutely worth filing for. There will be a window of 6 months when you can file for TPS. If you miss your opportunity to file for TPS, later you may have a very hard time restoring that deadline. Usually you have to present a good cause as to why you didn't file for TPS on time. TPS protects you from removal, gives you an opportunity to file for travel document, which is much easier to receive than a travel document while you have asylum pending. A big, huge difference. If you withdraw your asylum application, you will be able to visit your home country with advanced parole. Of course, if everything else is true and correct. What else about TPS? TPS is considered to be a lawful status while you are in TPS. Extremely, extremely important. This is something that's coming from USCIS manual. Lawful status. Very important. It does not cure violations of the status that happened before you received TPS. Okay? TPS is usually designated first for 18 months and then being redesignated. For the country to stop being qualified for TPS, there should be adequate notice and findings published. If you recall, Trump decided that he would cancel TPS for the countries that were designated for it, but court said no, not so fast. You cannot just cancel TPS once a country is designated for it. For that reason, I think that even though it says temporary, it's going to be rather kind of long solution and not temporary solution. Unfortunately, TPS by itself does not give you a green card or path to citizenship. However, it's still worth applying for. For that reason, I would encourage strongly everybody and anyone who qualifies for it to file for TPS. Extremely, extremely important that you would not miss the deadline. Again, right now, for the new countries, there is no opportunity to file. You just need to be patient. But anyone, even a person with removal, will be able to file for it. Now, if you guys have questions, I'll be happy to answer them. Hi, David. How, Dawa? What about people under order of supervision? If you have an order of supervision that is current, I would still advise you to consult with your attorney depending on when is your next day to check in, okay? Because your lawyer has to keep an eye on that lawsuit and see what's going to happen. I understand that the other sides, the plaintiffs, state of Arizona and some other states are planning on starting the physical removal. That's why they filed that lawsuit. They do not want people who have outstanding orders of removal to stay in the United States, right? So that's what's happening, and it's very important that you consult with your attorney. So you're going to have um, a game plan as to what you're going to be doing. Order of supervision and administrative stay of removal are two different things, just so you know. All right. So currently, people who were subject to this enforcement priorities, they could not care about the administrative stay of removal. But in a situation where the government is going to actively start deporting people again, you will have to care and you will have to file for administrative stay of removal if you do not want to be removed. It's extremely important. Hi, Tia. Hi, Mustafa. Hi, Ali. Watching you from Chicago. Hello. Hi, Mustafa. Is 2 years normal waiting for BIA to accept the appeal? Um, is it appeal of USCIS decision, or is it something that, or is it appeal of the court's decision? USCIS decisions are taking very long time to be transferred to Board of Immigration Appeals by USCIS attorneys. But generally speaking, all appeals are taking a very long time. Okay. So as long as your lawyer did everything correctly and you have notices that the case was appealed on time, I wouldn't be alarmed. It does take a very long time for the appeal to be processed. Hi, Tia. Can I file U visa if my case was closed? What case was closed? Were you a victim of a crime? Do you mean that the person was not convicted? Yes, you can still file as long as you have a U visa certification. Okay. As long as you have a U visa certification, the government has to sign off on it. And if you have it, you absolutely can and you should file. For the U visa, you have to show that you were a victim of a crime specified in the law or similar criminal activity and you suffered a significant harm. Okay. And then absolutely you should file. Why absolutely you should file? Because there is no danger in filing that. It's a humanitarian relief, you're entitled to it, and it takes forever to receive it, but it comes with an opportunity to receive a work permit and you're protected from removal while the U visa is pending. So why wouldn't you do that? Hi, Kojo. What about people who apply for asylum inside the United States? It means people who came with a visa and apply for asylum. Um, Please let me know what your question is. If you came on a visa and you file for asylum, you have asylum pending. Is your question relates to TPS? Should you still file for TPS? My answer would be yes, you should. Okay, usually it's a generalized answer. Of course, you should consult with your particular attorney. Maybe there is something that would prevent you from filing for TPS, or you don't want to deal with it for some reason. But from my experience, usually see that people who don't file for TPS when they have an opportunity later regret it. Okay, that's what I see. Hi, David. What about caregivers? Do they qualify for healthcare industry? Caregivers, yes, they do. Yes. Submitted. Hi, Chikal. Submitted time on 30 August of 2020. Got an RFE November. Replied January. As of May 2021, it shows actively been reviewed. Oh, yeah. Well, listen, I don't rely on this online announcement that your case is ready for the interview or actively being reviewed. It will be actively reviewed for years. It doesn't mean anything. So if your case is within processing times, there is not much you can do. If it's outside processing times, then you can ask congressmen to expedite, not to expedite, just to make a decision. If you have a ground why the case should be expedited, let's say, something relates to a difficult situation in your home country, maybe you're waiting for status to sponsor somebody else, then you can request for your application petition be expedited, as long as you can meet the guidelines. Okay. For example, many people who are sponsoring now relatives from Ukraine and filed I-130s for them, they can call USCIS customer service and ask for those I-130s to be expedited. It's very important. If USCIS agrees to expedite, then it's going to take them only 45 days to give you a decision rather than several months or a year. So it's a big difference, okay? But I wouldn't rely just on those online updates. Hi, should Russians after 1 year deadline apply for asylum because arrests of no protests? Well, that's a good question. I wouldn't generalize that every Russian person should, but if they can they? I think they can. If a person finds himself in circumstances where country conditions change significantly, and I think the recent event may be exactly that event, a person should consider filing for asylum or perhaps filing motions to reopen their old cases based on changed country conditions, and they have to act within a reasonable time. What's reasonable time depends on circumstances, but usually it's about within 6 months of the changed country conditions. All right, but can they? Depending on the circumstances, I think they can in this particular situation. Hi, Mustafa. Is it normal waiting for BIA to accept the appeal? I think we discussed that. Hi, David. Which countries are eligible for TPS? You can find a list of eligible countries at the USCIS.gov website. And I also published that list on my website, sheltsova.com. I will not remember all countries by memory. Is not that perfect, but I'm going to tell you, I believe it's El Salvador, Honduras, Venezuela, Haiti, Yemen, Syria. Recent designations were Afghanistan, Ukraine, and Sudan, if I'm not mistaken. Yes, so you can check that specific list on the website. Only if you're national of the country, you will be able to apply, and only within a certain time, okay? So even if the country was designated, let's say, a long time ago, and you arrived in the United States now, most likely you will not qualify for TPS unless the country is redesignated. Redesignated, it means not just an extension of TPS, but again is designated. That's what we saw recently with Haiti. So people who were from Haiti for a long time, even though country was designated for TPS, if they missed the initial deadline, could not get TPS. But because the new administration renewed their designation, they were able to file again. That's how it works. Hi, Ron. Just curious about Russians living in the United States who don't have a green card yet. Would they have to go back? To have to go back, why exactly? And if they don't have a green card, do they have status? I'm not aware of any law that would say that every Russian person, just because they belong to Russian Federation, will have to exit the United States. There is no such statement, right? So I think Russians will be treated just like everybody else. If they have a legal status, if they have status, they will be able to stay in the United States. If they do not have legal status, they can be placed in removal proceedings. Currently, deportations to Russia, just like deportation to Ukraine, Belarus, Hungary, Moldova, are stopped, paused because of the situation. DJ Brashy have order of removal from 2003. I filed I-130 in 2016 through my brother. Do you think I'll have a chance to get my green card? Well, you probably are aware that if it's your brother who's sponsoring you, you will not be able to adjust status in the United States based on his petition, right? I hope you know that you most likely, unless you can adjust using 245I exemption, you will have to leave the United States and come back. But if you have an order of removal, then you will need waivers to do that, or you can, somehow, most likely you will need waivers. That will be my initial guess. Okay. Of course, should discuss with the situation with your attorney, but usually someone who has order of removal, first of all, cannot adjust status without opening the removal proceedings unless they are an arriving alien. And second, if you're in a preference category, you're also subject to 245C bar to adjustment, meaning that you would have to demonstrate that you were in a lawful status throughout your stay in the United States. Okay, so unless you can do that directly, you will not be able to benefit from it. But with the waivers, perhaps you may be, or maybe you're subject to 245I. I don't know. Hi Manoj, U visa bona fide determination and work permits updates and which years they are certifying. I do not work for them, so I do not know exactly which years they're certifying. But judging from the rumors, I believe it's 2017. This is the year that they're reviewing. They're just rumors, okay? Have not seen any recent updates directly from USCIS. It's only from lawyers who filed cases and who started receiving those letters, right? Allowing people to file for work permits. I can say that it's about 2017. We have to be patient. We have to be patient. Hi. Case closed, benefits received by other means. What does it mean, please? Well, it means that a person was able to receive their green card perhaps based on some other basis, not the basis that they were filing for. Or perhaps it was in relation to a work permit application, right? It's hard for me to say because I do not know what case was open. But it means that person received what they were filing for some other way. Highly. What is my consultation fee? It's $250, published everywhere, including about me, seeing on the YouTube, and about me, whatever it's a section, I guess that's how you would call it. Can I withdraw my asylum application, apply for TPS? What if the status of my country no longer falls eligible for TPS? What will happen to my asylum case? Will I still be able to apply again? I think these are perfect questions for your attorney. Who filed your asylum case or helped you to file your asylum case. This is a personal decision whether or not you should be withdrawing your asylum case. I will not be able to tell you, David, if you have to do that. I can only tell you about the general consequences. I believe that if you withdraw your asylum case because you rely on TPS, and perhaps you may have good reasons to do that, later, if you would like to file your asylum case again, you may face a problem of 1 year deadline. Okay? And you will have to also argue for an exception from 1 year deadline. I personally think if I had to guess as to what's going to happen in the future, it will be difficult to qualify for those exceptions. So you have to really see if it's going to be wise for you to do that. Nothing prohibits you from keeping your asylum application pending and pursuing TPS, right? But of course, this is something that should be determined by you and your attorney together, depending on your goals, what you want to do, what you want to achieve. What is your final goal? What about your dependents? TPS does not give any status to dependents, right? This is something to be aware of. Hi, Edison. I come from Germany and my daughter, 9 years old, live in the US with my ex-wife since 2017. Can I get a green card because my daughter is here? My daughter needs her father. Just because you have a child who lives in the United States, generally speaking, no, you can't get a green card. There is no such an opportunity. You will have to file for something separately from your daughter. If your daughter is not a US citizen, she won't be able to help you at all. Well, once she is a US citizen and 21 years old, she can file for you. But unfortunately, there is no way around this situation when you are of a different nationality, you have a child who lives in the United States and would like to stay with a child. There is no opportunity or any provision directly in the United States immigration law that would allow you to file for some direct status based on that. So I suggest that you consult with a lawyer to see if there is something else you can file for based on employment petition, some humanitarian relief if you qualify for it, how you may maintain your residence in the United States. It's a tough situation. Hi, Homar, had my removal proceedings on February 1st, 2022, but all of a sudden it's no longer. I'm waiting for the next court date, but it doesn't exist. Oh, yeah, your case was taken off the calendar. Happens all the time nowadays. I wouldn't worry about it at all. It means that your lawyer is going to receive a notification by mail as to what's going to happen next. Next, you may receive a scheduling order, and perhaps if pleadings were not done, you will have to do the pleadings. Even if they were done, sometimes you have to redo them, or your lawyer rather. And then the court is going to issue when you need to submit your applications for relief. So this is a normal practice these days. What's stressful a little bit that you don't receive the cancellation by mail significantly in advance of your hearing. And on the day of the hearing, you find out that it's canceled and you get all stressed out. No need to be stressed out, guys. It's a practice. It's a new reality we have to adapt to. Unfortunately, yes, it's the truth that you may find out that your case was taken off the calendar on the day of your hearing. Nothing to worry about. You just have to wait. You may ask to advance your hearing date, depending on the circumstances, if you don't want to wait, okay? There was such a window of opportunity with all the cases were canceled due to coronavirus recently. So it's something to discuss with your attorney if it's worth it for you to do that. But by itself, it wouldn't alarm me. That's kind of a normal situation. On March 3rd, 2022, we closed your I-765 case. Oh, yeah. So I think you asked me this question about the fact that the application was closed. I guess that it was I-765. It means that the person received work permit somehow else. At least USCIS believes so, okay? That you received the status or work permit somehow else. So if it's not the case, you have to consult with your attorney and tell them that you don't have it. And they think you do have it. So there is something going on. Well, guys, thank you very much for watching. Please share, like this video. It will help other people and it's going to help my channel to grow. And I do appreciate you participating and joining me today. I will continue to update you with regard to the most recent immigration news. Many people are asking me when windows for TPS is going to be opened for the recently designated countries of Ukraine and Afghanistan. As soon as I know that, I will let you know. For now, you can start preparing for it, collecting documents such as your birth certificate, copies of your passport. You should absolutely do self-background check to demonstrate that you're a person of good moral character. Perhaps if you were paying taxes, you should have that. Government issued IDs. You should have to demonstrate that you resided in the United States since March 1st or March 15th, I believe, for people from Afghanistan. And again, thank you very much for watching. It was a pleasure, and I hope to see you soon.